Welcome to another Wednesday night for Chaz Calenda, attorney at law here on the Coalition Radio Network. I'm Chaz Calenda. I'm an attorney here at the law firm of Inman and Torgy in Coventry, Rhode Island, and I'm also a candidate to be the next Rhode Island Attorney General here in 2022. I'm here every Wednesday night on the Coalition Radio Network talking about a vast array of legal issues facing us here in Rhode Island and around the country. Tonight, we're going to actually focus on a topic that we very rarely focus on, me, in my candidacy for the Attorney General here in Rhode Island coming up here in 2022. To help me talk about this tonight is Pat Ford, station manager here at the Coalition Radio Network, and he joins me right now live. Thanks, Pat, for helping me discuss me tonight.
And tonight's award for narcissism and self-absorption will be moved from its traditional recipient, which is me, because it is tonight all about you and your opinions on really a range of issues. It's been an exciting week here in Little Rhode. We like to sign off sometimes with the dulcet sounds of one Rudy Cheeks, who used to say, "Sleep tight, Rhode Island." There is no chance of that happening at any level, at any place right now. Pretty crazy stuff. So let's get ripping. Let's dive right in. When last we spoke, we were off the air last week, but when last we spoke, a tragic and a serious situation continues to evolve here in Little Rhode. Heartbreaking, unnecessary, tragic, and heartbreaking. And while everyone is just heartbroken about what happened, if you're a parent and you see what happened, what transpired, and a lot of us can think back to when we read about this story. And for a lot of us, our knees literally buckled. That's the kind of emotional response you have when you've got a son or a daughter. And you know, maybe I'm old school. There's something about a dad and his daughters. I have two. They're amazing young women. It's cliche. It's trite for me to say this, but I can't even imagine the pain that this family is experiencing on every single level at every single moment. My heart breaks for them, and I like to think of myself, and I know I think of you, as individuals of action. Nothing I say will bring comfort to a family like this, but all I can say is in my little seat here, in our little network, the little network that roared, we will do everything imaginable so that this will never, ever happen again on our watch. Because it is on our watch. It is our responsibility as a citizenry, not just the media, but as a citizenry and the media, to put a spotlight on the criminal justice practices of the state of Rhode Island. No one gets off on this. Every one of us must be accountable to this system. The system is of our collective creation. It is our collective responsibility to watch over them in every single matter. This is the logical extreme of what people have been screaming about for a number of years, about competency in government. And, it's the age-old, someone will get hurt. If only someone had just gotten hurt. A young woman who was ripped from her family, she died. Every ancillary issue about this, what town she was from, her background, what she'd accomplished in life. Let's put that aside and understand that a child, a daughter of Rhode Island, died unnecessarily. And she was a daughter of everyone in Rhode Island. Words. I've got plenty, but they're meaningless.
And I'd probably share the same sentiment as you. I do share the same sentiment as you, Pat. There is no words that I could use. I'm not a parent, and I certainly can't begin to put myself in the situation that family must be going through. I try to look at it from a perspective of, what went wrong, to put us where we are, looking at the situation as we are, where the blame should lie, because let's face it, there's plenty of blame to go around here. And as much as I'd like to blame it all on the current administration of the Attorney General, I can't. There's a lot that goes into this. But there is plenty to blame as far as why the perpetrator was allowed to be in the position that he was in to kill this 17-year-old girl, Olivia Passaretti, on January 1st of this year. And there's so much wrong with what happens, and there is so much trying to pull back from it from the current Attorney General that I think we deserve some answers. And I'm going to try to give you those answers tonight of what went wrong, what can be fixed, and what the current Attorney General should be saying if he had the fortitude to come on your show and answer these questions.
Let me start out with one. I think that while it doesn't address the facts of the case, it's salient and needs to be answered. Is there ever a situation where a deeply flawed government outrightly fails its citizens, and in this case, a family from East Greenwich? Is there ever a situation where, and this is what's being currently spun, that cannot be discussed in an appropriate, mature framework as to why it happened? Is there ever a situation where we can simply dismiss any conversation about it as politics when we seek answers and accountability to what happened, and of course, as I mentioned just a moment ago, exercise our responsibility of citizens to do everything humanly possible not to let it happen again? Is there ever a situation where, for political correctness or quote-unquote polite society, that we should allow the facts and circumstances surrounding this case to be brushed under the rug, as it were?
Absolutely not. And you know what? Certain commentators here in Rhode Island, certain personalities in Rhode Island would dismiss my answer as, I'll just quote unquote refer to it as poppycock, and that I'm using this for some sort of political gain in my quest to become the Attorney General. Couldn't be further from the truth. There's nothing more important that we should be doing than holding our government accountable and getting answers for a situation that is so tragic as this one, that it is just, that we should just push it aside, not talk about it just out of the sake of political correctness or polite society. That is not appropriate a reaction to a situation like that. So poppycock aside, we are going to discuss what has to be done so that these kind of situations, they'll never be eliminated completely, but we can put ourselves in a situation where we can try to reduce the chances that something like this will happen again in the future.
And a final thought on that subject. Is it not a direct function of the electoral process? Is it not the responsibility of the quote-unquote campaigns from any serious candidate for the office of the Attorney General? Is it not the primary role of said campaigns and conversations and debates to specifically address issues of law, issues of procedure, issues of responsibility, issues of approach? Isn't this exactly what the damn campaigns are supposed to be about, as opposed to the usual, horse racing, I'm going to handicap who's going to win, I'm going to obsess over campaign financing? Isn't this exactly what we should be damn talking about in the midst of a campaign? Accountability, responsibility?
Couldn't agree more, Pat. This is exactly, especially for the office of the Attorney General, the chief law enforcement officer of the state of Rhode Island. This is exactly what we should be talking about. It is unbelievably tragic, and that is an understatement. And I just don't have better words to give you to describe the situation. It is unbelievably tragic that we have to use a situation like this to talk about it. But this is what we should be talking about. Not how much money is in my bank account, not how many polls I've taken to determine where I stand in this race or what my chances are of winning this race, not how many messages that resonate with people in a poll tested situation. This is what we are talking about, the office of the Attorney General. How my office and how my administration, if I were to win, is going to keep the Rhode Island society safe. What am I going to do to prevent situations like this from happening again? This is exactly what we should be talking about.
Amen. So let's review the facts of the case. It's been a few weeks. There's a lot of conversation, a lot of rhetoric flying around. In the words of the immortal, just the facts, sir, just the facts.
It's, the biggest problem that I have seen with this is that, the current Attorney General kind of brushing off the notion that this was somehow preventable or somehow foreseeable. I reject that outright. I reject that outright for a number of reasons. And the number of reasons are just fact-based. You look at this person who had a criminal record going back to 2010. At the time of his last prior sentencing, which was February 14th, 2019, under Peter Nerona's administration, he had 6 prior felony convictions, almost all of which were for crimes of violence. He also had multiple misdemeanor convictions, many of which were driving offenses. He was given several sentences to serve at the ACI for his felony convictions, the 6 he had up until 2019. He had been violated on his probation more times than I was able to count on all those 6 felony convictions that he had in 2019. And in 2019, Peter Nerona's office offered this man a suspended sentence and probation with no jail time on charges of breaking and entering into somebody's home. That's a home invasion. And possessing a stolen motor vehicle and conspiracy to do so. So literally able, despite the fact that he was on probation, had 6 prior felony convictions at that time, some of which, again, were crimes of violence, was a registered sex offender. He was able to enter those pleas on February 14th, 2019, and walk out of that courtroom that day a free man. I don't know about you, Pat. You don't need a crystal ball to figure out that that's probably not the appropriate sentence for an individual of that background and caliber. And that given his repeated recidivism, his repeated violations, his repeated flouting of our laws, why on God's green earth would there not be a recommendation for some sort of prison time from the Attorney General's office? They don't need to have the habitual. I've mentioned the habitual offender notice, but you know what? It wasn't available to them at 2019 because Kilmartin's administration didn't serve him with the papers. Fine, we'll put that aside. Breaking and entering after having prior convictions for that charge, which this person had 2, breaking and entering is punishable by up to 15 years in prison. Possessing a stolen motor vehicle is punishable by up to 10 years in prison. They could have asked for a significant amount of jail time, and they did not do so. I have to assume they did not do so because the Attorney General was asked many times, was this your recommendation, your office's recommendation, or was a judge just simply imposing that sentence over your objection? He refused to answer that question, even though he has that information in his office. So I'm going to assume that this was the recommendation of his office, and he just does not want to discuss that. So this is the genesis of the problem that brought us to where we are today. We had a violent repeat offender walk out of the courtroom in the Superior Court in 2019 to be simply set up to be put back on the road, where he was in a position where it appears he had a plan to go out on that road and wreak havoc in whatever way possible, did so, and apparently perhaps bragged about it after the fact by saying done. To me, that sounds about as heinous as it possibly can get.
And we're left with what?
We're left with a dead 17-year-old girl that we just, as a community, just are trying to wrap our heads around. And we're, as a community, trying to wrap our heads around, how does this happen? How does this happen when you have a criminal justice system full of judges who have probably been there for, some of them have been there for decades? How does this happen when you have an attorney general who is a former U.S. attorney appointed by a former president of the United States, a former assistant U.S. attorney, a former assistant attorney general? How does this happen when you have somebody with this kind of background, that it slips through all sorts of checks and balances that are supposed to be in this system, to allow him to walk out of that courtroom without handcuffs on, not on his way to the Cranston Hilton, as we so affectionately call it in the criminal justice system?
Let's talk also about the role of probation. How does the probation system work in Rhode Island? Give us a breakdown of what's supposed to happen when, despite all evidence to the contrary, that the gentleman in question should have been incarcerated, and they're issued probation. If you could differentiate between probation and parole, and who specifically oversees probation?
So probation, well, let me start with your first question, differentiating between probation and parole. Probation is a type of sanction. It's not technically a sentence, but probation is in colloquially referred to as a sentence, where you admit to a charge, or you're found guilty of a charge, and you are assigned a probation officer who is under the Department of Corrections purview. And you are required to check in, perform any special conditions of your probation, keep the peace and be of good behavior, which means you don't get arrested again. You're not getting into any further trouble. And you are on that for a certain period of time, which is set by the court. Parole is your ability to be released early from a sentence, an incarceration sentence, which is solely within the purview of the Department of Corrections. You go before the parole board, you make your case after a certain amount of time that you've served at the ACI, and they decide whether or not they are going to grant you a release from the ACI in your prison sentence under certain conditions. However, you're still technically under sentence at that point. So when somebody is placed on probation without a jail sentence attached to it, somebody's placed on probation, there are apparently 3 levels, according to, I saw a recent response from the communications director over there at the Department of Corrections. There are 3 levels of supervision. There's high supervision, or the regular supervision, where you're required to check in regularly. You're required to prove to your probation officer that you're doing everything you're supposed to be doing, complying with the conditions of probation, and that you are being regularly monitored by your probation officer. Then there's a lower type of monitoring where it's probably less frequent checking in, but there's still somebody assigned to you to make sure that you're doing everything you're supposed to do. You present less risk based on your overall profile, your background, your criminal history, your ability to follow the rules and not get in any further trouble. So they assign you a lower risk category. And then there's the bottom risk, which is, I believe they refer to it as the minimally supervised risk. And I think that's just a play on words, because in reality, in the criminal justice system, it's really referred to as inactive probation or unsupervised probation. That's where you are, your case file is essentially placed on inactive status. You're not checking in regularly. They consider you a low risk to reoffend based on your overall profile again. So, and you're really not visiting anybody. Nobody's checking in on you. Nobody's making sure you're doing what you have to do. A lot of times that's done because there are no conditions of your probation and you have nothing in your background that would suggest that you present a risk to reoffend. This individual, Mr. Segura, was less than 3 years into his 8-year probationary sentence, placed on the minimally supervised probation, the inactive probation, according to the Department of Corrections. So nobody, in effect, was watching him. So when he was placing these allegedly, and I'm going to use the word allegedly because he's entitled to a fair trial at this point, when he was allegedly putting these Facebook messages online, talking about how he's going to F stuff up on the road that night, nobody was watching that.
So is it fair to say, Counselor, that literally every single step, every single benchmark, every single, if you will, check and balance, every single individual in the Rhode Island criminal justice system failed Miss Olivia Passaretti?
Yeah, I would say that's a very fair assessment. And like I said, it doesn't start with this current attorney general, because there was a failure before that under the Kilmartin administration. What should have happened in 2017 or 2018, whenever the cases that he pled to in 2019 were brought originally to the Superior Court, the Kilmartin administration should have served him with a habitual notice offender notice. That would put him on notice that if he is convicted of those offenses, that he is liable to serve up to an additional 25 years in prison if the judge so decides to impose that. But because that wasn't done, that was not an option in 2019. That did not in any way hamstring the attorney general at that time, Peter Nerona, from seeking a significant jail sentence. It just prevented him from using the enhancements that were ultimately available to his office for any person who has been convicted of 2 or more felonies and sentenced to serve in prison for at least 2 or more felonies. That was not done.
I guess it's a rhetorical question, but why the hell not?
Well, just from my experience, I had been working in the Attorney General's office during that time when these cases probably originally came in. I was not in that county, so I don't know for sure, but I can tell you just based on my experience that the unit that would be responsible for reviewing this person's background would be the screening unit. And the screening unit would be reviewing the case to make sure it had the adequate evidence to go forward in the Superior Court, and preparing any notices like a habitual offender notice to be served at the arraignment or no later than the first pretrial in the Superior Court. That's rarely ever done. And there's good reasons that that's not always used, because it's not always appropriate, Pat. The law says you can do it after a person has been convicted of 2 felonies and sentenced to serve in prison for those felonies. It doesn't mean you have to do it. But you got to look at every individual differently. You've got to look at their individual situations. And it clearly was not done in this situation, and in a situation where it would have been appropriate to at least put this person on notice that if you are convicted of your 7th and 8th felonies here, you are going to be at least subject to our request that the court impose the enhancement, the penalty, the habitual enhancement penalties upon you. And it's inexplicable why that was not done in the first place. And it's inexplicable why the current administration did not seek to remedy that by seeking a severe enough sentence, which would have kept Mr. Segura off the road on January 1st, 2022.
Can you talk about the technology that's in place allegedly to prevent this type of tragedy?
Well, just on the subject that we were talking about, this person's background, this person's prior convictions, who in Rhode Island keeps the official record of the official criminal records of everybody in this state? It is the Attorney General. It is the BCI unit of the Attorney General. They have that at their fingertips. The state of Rhode Island judiciary has a public portal that any single person of the public has access to look up any prior court case of any individual that's ever come across the Rhode Island judiciary. Apparently, that either was not done or nobody looked hard enough to find it. And I can't imagine, I know for a fact, because I use it on a daily basis, neither of them are very difficult to navigate. Neither of them are hard to do. All it took was somebody to look at it, make a notation in the Attorney General's file, prepare the notice, and have that prepared for the prosecutor to serve at the arraignment or the first pretrial. This is not brain surgery. This is not rocket science. This should be a matter of routine.
I think all of us assumed that it was. You've got this veritable army in Rhode Island geared towards criminal justice. Just on its most superficial level, we spend an enormous amount of money. We have an entire administration geared to specific incidents like this. Despite the fact that we are a state, most would argue, are at or lower than 1 million people, we have a regime in place. And again, I phrase my questions this way, by the way, because, I normally will joke about this. We're not joking about anything tonight. But while I think of myself as someone who pays attention, I am not like or unlike every other Rhode Islander who has clear assumptions about what goes on in the halls of justice. And the systemic failure in place here is over multiple departments within multiple jurisdictions of Rhode Island state and local government. The collective failure here is immense. Despite
gigantic.
Despite a significant investment in technology, despite an astonishing investment in personnel and their salaries, and we are faced with a level of systemic failure that is incomprehensible still to me, despite the fact that we're 3+ weeks later. Now, we move into the situation at hand, and clearly everyone is aware that there's great controversy surrounding the charging in this case. Maybe if people had spent a little bit more time involved in the charging, if you will, of prior cases, we would not be having this conversation tonight. We'd be making light jokes about the next Supreme Court justice, but we're not. We're here. There seems to be a great deal of confusion over how Mr. Segura ultimately will be, or as importantly, can be charged. Can you give us again your background? And for folks who might be joining us for the first time tonight, who happen upon the show or happen upon it in replay, I need to note for the record here that Attorney Calenda, who is the host here, has 12+ years experience as a criminal prosecutor in the Rhode Island Attorney General's office. In addition to that, now is engaged in private practice as a defense attorney around a number of criminal environments. So while light is often made about attending Facebook University if you're arguing about masks and issues like that, or a lot is made about folks who Google issues. We're talking about, arguably, a highly experienced, a highly technically skilled subject matter expert here. That's who we're talking to right now. We've often thrown back and forth the notion of how few attorneys in the state actually try cases. You have tried, I couldn't even begin to put a count on it, here in Rhode Island, of virtually every level of either alleged, purported, or actual criminality. So I just want to make that clear to folks that we're talking about someone who is not just a subject matter expert from days gone by, but someone who is intimate with the criminal justice system literally on a day-by-day basis, 5, 6+ days a week, in court, in hearings, consulted to and by legislators, someone whose life work literally is the criminal justice system. I need to make that case because of the severity of the issues involved and the heartbreak for all of us who, again, lost a daughter of Rhode Island. So talk to us about the charging, if you will. What's at stake here? And the singular issue that's arisen in the last few weeks, as brought forth by the family, who have, again, every right and should be given every opportunity to discuss this, is about a murder charge. So if you can just walk us through the entire system, as you so often do on this show.
Sure. So right now, as the police have charged Mr. Segura, they've charged him with leaving the scene of an accident resulting in death and driving to endanger resulting in death. Those are punishable by up to 10 years in prison. He's also, because he's on probation, he's also facing a probation violation, which would potentially put him in jail for another potentially 8 years if he were to be found in violation of his probation. That's how he's currently charged. Those are, I don't want to, again, these are all allegations at this point, and as a criminal defense attorney, he's still entitled to the presumption of innocence at this point. So I want to make sure that we're making that clear. But looking at this from what we know from the public standpoint, from what's been released publicly, the family has been pushing the Attorney General's office to up this to a second-degree murder charge. And I know that other legal practitioners have opinions on this. I know there's one particular one that appears on Channel 10 who gave the opportunity to, was given the opportunity to weigh in on whether or not a murder charge would be successful in this case. And I believe his answer was there would be 0% chance that a murder charge would be successful. That to me is one of the most irresponsible comments I have heard in a long time. I'm not going to sit here and say it's a slam dunk that there could be a murder charge made, but it is not a far-fetched situation to suggest that this could rise to the level of second-degree murder, assuming these Facebook posts allegedly from Mr. Segura could be authenticated, where he's talking about causing this mayhem, where he's saying exactly what he's going to do, does in fact do it, and then confirms he's in fact done it, which is killing this individual. Now, he certainly didn't go out there, I don't believe, with the intent on targeting this young lady, Olivia Passaretti, but he certainly went out there with a reckless disregard for human life. And in law school, they call that depraved heart murder. if they can prove a reckless disregard for human life. Your actions are likely to result in, are so reckless that they are likely to result in either serious bodily injury or death to another person. And in Rhode Island, that rises to the level of second-degree murder. First-degree murder in Rhode Island is not on the table here. I will say that if they were referring to first-degree murder, I would agree. There's a 0% chance of that because there was no premeditation, and that in Rhode Island is required for first-degree murder. But if somebody can prove that Mr. Segura's intent was to go F stuff up, as he allegedly said on Facebook, did it, confirmed it, and it in fact did happen in the way that he talked about, there would definitely be a cause to bring this to a grand jury to decide whether or not there is probable cause to believe that he acted with such a depraved heart that he acted with reckless indifference to a human life by engaging in his conduct. And that would, in fact, rise to the level of second-degree murder. So their family is not off base when they are saying, please, Mr. Attorney General, please consider this, look at the evidence, and bring this to a grand jury to decide whether or not this is an appropriate charge. And because second-degree murder can carry a penalty of up to life in prison, a grand jury would be required here, and it would be an appropriate use of a grand jury. And I heard Mr. Noronha originally, when this matter happened, when this incident originally happened, kind of poo-poo the notion of this. He has since kind of backtracked. I saw his interview the other day with Brian Crandall on NBC 10, where he's saying nothing's off the table now. I think he's realizing that his nonchalant attitude when he was originally asked about this did not play well with anybody, let alone the family, when he seemed to callously brush off the notion that this is anything other than a tragedy, an accident. So I sincerely hope that Mr. Noronha is going to look at this from an apolitical point of view and bring him, let the evidence bring him to a proper conclusion of what the charges ought to be in this particular case.
So you've got really two sets of needs/demands. Number one, inappropriate charging, which my understanding, as you present it, requires a grand jury. Number two, there's accountability within the criminal justice system. So you've got a couple of different groups involved. A significant part, of course, which is played by the Department of Corrections. And again, correct me, that they were, in a sense, in a direct sense, responsible for the migration of the accused during his prior probation to an unsupervised status, which is when this event allegedly occurred.
That is correct. The Department of Corrections, through probation, is solely responsible for the decision of what level of supervision that probation is going to be applied.
So what needs to happen to responsible parties in the Department of Corrections, and who would you say they are? And of course, what responsibility does the administrator of the Department of Corrections, Patricia Coyne-Fay, perhaps no more a failed apparatchik in Rhode Island government exists, and that's, as we say, saying something, folks. So where does accountability lie within that department? The subject, by the way, I should also say the embattled head of corrections, the Patricia Coyne-Fay.
Well, there really needs to be a full review of their protocols because, the press release, which I believe it was you, Pat, that requested the information from the Department of Corrections about Mr. Segura's probation status at the time of his new offense here, alleged new offense in 2022, the Department of Corrections laid out their criteria for how they decide what level of supervision a probationer should have. And if you look at that list of criteria, and I don't have it in front of me, but I think I remember it fairly well, that their list of criteria takes into account likelihood of reoffense, dangerousness, the ability to follow instructions, their ability to comply with the terms of their probation. I mean, anybody who has any familiarity with the criminal justice system and how probation works and how the criminal justice system works could take a brief, and I could say a very brief look at this man's history and say that that was not done in this particular situation. And I don't know specifically who's at fault for that or who made that determination. So I don't know who his probation officer was. And I don't know if his probation officer was the one who ultimately makes the call. It may be a supervisor. It may be somebody else within the Department of Corrections. But hey, the buck stops at the top. And the director of the Department of Corrections, Patricia Coyne-Fig, is ultimately the one who's going to have to answer that question. And I don't know that that answer is going to be forthcoming. I feel like it's going to be a similar answer that we got from Mr. Noronha, is that we don't have a crystal ball. We can't foresee the future. We can't predict these things. So, it's an unfortunate tragedy. And then we'll hear that song and dance over and over again.
Balderdash. All right. It's when I look at the Department of Corrections, this was as predictable as the Patriots' loss in the first round of the playoffs. This was as predictable as the storm that's going to hit this week. There is a clear set of events. And quite frankly, just again, as an outsider, someone not as well schooled as the wise men and women at the Department of Corrections, to me, looking at the history here, the shocker would have been if he didn't recommit.
I hate to say it like that, Pat, because I'm not a lock them all up kind of person. I'm not one that just says he did it, so he had a bad history, so he's definitely going to do something again. I'm all about people redeeming themselves and being able to prove that they can be reasonable and helpful members of society. But I mean, this was not that guy. And it was abundantly obvious.
Again, the shocker would be when an individual with that displayed degree of depravity doesn't recommit. And listen, anyone who knows me knows that I'm as reform-minded as anyone could be in Rhode Island about the criminal justice system. But there reaches a point where there must be a continued display of responsibility on a fundamental human level before an individual like this is accorded the level of freedom he was given.
Right. And if I remember correctly, Pat, in the response you got from the Department of Corrections, one of the reasons that they put forth as justification for his quote unquote minimally supervised probation was that he had completed his condition of probation, which was paying $400 and some odd of restitution. So that was their justification, because he had completed his special condition of probation, which was restitution. Never mind the fact that if you look at his history of prior probationary sentences, he had a multitude of violations of probation that some of which resulted in additional prison time on top of the time he had already served.
I certainly don't want to give this subject short shrift. We have a few other things that we'd like to talk about tonight. But, Counselor, could you please sort of give us a summation of what needs to happen here? And give us a little bit of a broad perspective. You're elected, you're running for office. Again, normally this show is a little less overt about that, but there's a lot of circumstances we're talking about tonight which demand the attention, the thoroughly appropriate attention of a candidate. Because again, if you don't point it out, no one else will. But let me just project a little bit. You're elected Attorney General in November. You assume office in January. Let's just project, perhaps a little unfairly, but let's just project that nothing is done outside of, say, we'll give credit where credit might be due, and appropriate charging. But nothing is done, as is so typical of the fashion of Rhode Island, other than, I don't know, maybe this will earn a couple of these people a $43,000 a month settlement. Oh, did I say that? But
Can I have one of those?
Yikes. What would you do as the new Attorney General in terms of a review process and an accountability project for the events as they occurred on January 1st of 2022? And I'll call it for what it is, the execution of Olivia Passaretti.
Well, Pat, the first thing I would do is institute a policy in the screening unit of the Attorney General's office that anybody who is eligible for a habitual offender type of notice or enhancement sentence be flagged as such. It does not mean that they will be necessarily sentenced in that manner, but a flag will have to be placed on that file, just like they do in certain other types of cases. There's a sticker that goes on a file for certain domestic violence cases, for certain gun cases. That somebody in that office, in that screening department, will be tasked with the responsibility to run that person's background, to evaluate whether or not that person is eligible for habitual offender notice. And that notation and flag will be placed on that file, and it will be placed in the case management system, which is currently in place in the Attorney General's office, which is their basically electronic filing system. So that way, the person and the prosecutor who is assigned to that matter in the Superior Court has a hard stop in their system when they see that they've been assigned this case, that this person is one that potentially should be served with the habitual offender notice. And at that point, somebody with experience in the office would also, I'd like them to weigh in and discuss whether or not it would be appropriate to actually serve that person with a habitual offender notice and have that discussion with the prosecutor who's going to handle the case. And again, it's going to be an individual determination. Not everybody who's eligible is going to get that notice, but we have to look and do a thorough review, not just a cursory review, which has been the tradition in my experience within the Office of the Attorney General that the screening unit gives. They look for probable cause, they sign the criminal information, or they put the matter into grand jury, they return a true bill, the case is sent to the Superior Court, and that's the last that you ever hear about it until it gets pled or the case goes to trial. There will be a full revamping of that unit under my administration to make sure that there is a hard stop for people who have a history similar to this individual before anything can be done with that. And if it's not done, that in and of itself will be cause for disciplinary action for the person who did not do their job.
Folks, if you're just joining us, you're watching or listening to Chaz Calenda, Attorney at Law. We just spent the last 40 or so minutes going really through an in-depth analysis of the tragedy of January 1st, 2022, the death of a daughter of Rhode Island. We'll be sharing this with the Rhode Island community tomorrow around social media. We invite your reactions, your thoughts, your reflections on just what we need to do in this state to achieve a balance between due process and the protections of the rights of the accused in egregious situations like this, where a bureaucracy that exists, a highly compensated, some would say bloated, but certainly in place bureaucracy exists to protect the fundamental rights and well, in this case, the life of our extended Rhode Island family. Clearly, that balance doesn't exist in either direction. And I will say this for one last time tonight. Clearly, this is exactly the type of conversation that needs to take place now, not somewhere in the future, not somewhere behind closed doors, not somewhere in a grand jury somewhere, but needs to happen throughout the entire Rhode Island family now, before we move further in our support of ideas, institution, candidates. Wow.
No, Pat, if the candidate to be the attorney general can't talk about it, who can? I don't know the answer to that.
Right. Because there is none. This, again, sort of a final reflection. This is why we have elections. This is why, by the way, elections matter. This is why, particularly in the technical, if you will, statewide executive offices, like the Attorney General's office, like the General Treasurer's office, like the Secretary of State's office, this is why it should be more than just who you played hockey with at the Mount. This is why it should be more than, who's part of your political circle. This is why it's more important than any of the events happening in far-flung places. This is why these jobs matter to us here in Rhode Island now, and why they should be the sole focus, the near obsession of the people that we would elect to run them. Chaz, a lot of other things have gone on in the week or two since we've been on the air live. And by the way, Chaz's travel has cases, let's just say, when you're a trial lawyer's lawyer, when you're just, I often talk about a writer's writer, someone who is immersed in writing, for whom writing is really a reflection of them as an individual. The same thing exists with trial lawyers. Trial lawyers, it's if you're awake, you're working. And sometimes even when you're not. You get the calls, the rush trips to a police department, the home visit because of a tragedy. This type of work doesn't observe or honor banker's hours. So occasionally we'll do repeats, but we're back again today. And a lot, again, has transpired. Very important issues, not nearly the level of tragedy as in the case we just discussed, but they're important nonetheless. The Rhode Island Republican Party last week brought a lawsuit against something called the Rhode Island Redistricting Commission, hashtag RI Redistricts or whatever hellspawn marketing nonsense they developed. And let me just lay the groundwork, basically, because I am not an expert on redistricting, but every 10 years we have a census. And Rhode Island general laws, as well as federal laws, then require that we adjust, if you will, the boundaries of representative districts based on a combination of statute and also extensive, and I mean extensive, case law. In this case, shockingly, a number of the folks who are intimately involved up in Halitosis Hall in the redistricting may have, just may have, abused the process for their own personal electoral benefit. Now, when I say that, I hope no one is drinking hot liquid or operating heavy equipment, because we don't want to shock anyone. But the trolls in redistricting, I think the technical term is gerrymandering, are at it again. And boy, are they at it. Now, you've had a chance. We posted about this. Apparently, we're one of the only people to post about this lawsuit. But I like your reaction. You had an opportunity to read the complaint. Give us your snapshot on what you think has happened here, what's going on, and then we've got a special case in Smithfield we're going to just touch on briefly before we get to today's resignation of Justice Breyer. Chaz, take it away.
Well, it looks like the Rhode Island GOP had filed a complaint, an Open Meetings Act complaint against the Rhode Island Redistricting Committee for, amongst other things, having a rolling quorum, which is something that the Open Meetings Act prevents or prohibits, I should say. And that's really where you have less than the majority of people needed. You discussed pertinent matters that were not advertised to the public in a specific way. And although they started with less than a quorum, the conversation kind of kept going on to the point where it reached a quorum of people at different times, where issues were discussed that should have been discussed in an open setting, in a way that was properly noticed to the public. And the Rhode Island GOP says it wasn't done so. The response that I saw was from the redistricting committee was, we're not subject to the Open Meetings Act because we're the General Assembly. Well, that's not true. The public laws in 2021, which created this redistricting committee, specifically said it is subject to the Open Meetings Act laws, and they are a public body for the purposes of Open Meetings Act. So put aside the partisan stuff. Put aside the fact that it was the GOP that filed the complaint. Anyone, any taxpayer, any voter of the state of Rhode Island could have filed this complaint. Let's look at the merits of it. And quite frankly, who should be looking at the merits of it and supposedly is the Attorney General, because he has the authority to take action on Open Meetings Act complaints. And that's where the complaint was made. It was made to the Office of the Attorney General. And it wasn't just the rolling quorum complaint that we had. There were, I believe, 34, I think the number was 34 separate violations alleged in the complaint by the GOP against the Redistricting Commission. I think you touched on a few of them, Pat. And, I don't know that we're going to get an answer before the election takes place, simply because it doesn't benefit the party that's in power if they have to address that. It doesn't benefit the Attorney General if he has to make a finding against the party of his own brethren. I just don't see there being a quick resolution to this.
Why is the concept of open meetings so important for democracy?
Transparency. This is what we're missing in Rhode Island. This is what I'm running on. This is the whole idea of why I want to be the Attorney General. It's not because I want power and fame, or I want to be some household name or something along those lines, because God help me, I don't want any of that stuff. What I want is a transparent, open government that's accountable to the people, so the people can make informed decisions about who should be leading us. And they can only do that if they know why certain decisions were made by our elected officials or appointed officials. If they can only know why those decisions were made. And the only way they can know why those decisions were made is if they were made aware of when these decisions were being made, how they could be a part of it, how they can listen or watch it being done, and the reasons behind it, and made public, and those reasons made public to the general public. That is the whole purpose of the Open Meetings Act, the Access to Public Records Act, APRA. That is the whole purpose of everything, and of transparency. And when you don't have transparency, you have the state of Rhode Island in a nutshell, because Rhode Island may be the most opaque government that exists in the United States, based on its absolute, I would say, best efforts to keep their actions secret from the public. And they've done it in every single setting that I can think of. The Office of Attorney General is one of the most misunderstood and opaque offices that exists in state government. You see that these contracts that are being awarded to companies for whatever reason, or bidders to whatever reason, are being done without any public input many times. We just had a buyout of our Department of Health director, who's now making a year's salary in 3 months after taking a month off. Was that subject to open meetings? I don't know. I don't know if that's not subject to an open meeting act, but where's the transparency in that process? That's what I'm asking for. So even if it's not necessarily subject to open meetings act, where's the transparency? Where's the public input on that? Where was the review of the rest of the public officials on whether or not that was appropriate? It wasn't there, and we don't have an attorney general who has done what he promised us that he would do when he assumed office by holding public officials accountable and making them transparent. And that's the biggest thing that we're missing in this state.
It's amazing to me how many good government organizations have taken a pass on this. And the most notable to me, and if I'm wrong, please correct me. I've reached out to them a number of times over the last year or two. I get no return phone calls. Is an organization called Common Cause of Rhode Island. They consider themselves the good government group taking on gerrymandering and redistricting, except they don't. And their silence is, as they say, deafening. Now, it wasn't always this way. A guy named Phil West, Dr. Phil West, who is a minister by trade, was for a number of years the head of Common Cause Rhode Island and did an admirable job. I got to get to know some of those folks when I actually served on a commission that sought to bring back and successfully brought back some level of the ethics code. And the ethics committee re-empowered them, if you will, after they had, and essentially their feet knocked out from underneath them in a lawsuit going back, a number of years. So for years, we didn't have a really powerful ethics code as it affected our legislatures. Now moving forward to this, it's interesting. I'm on commoncause.org/Rhode Island/Media Center. And the last comment they had was, of course, about the obsession over prison gerrymandering. And that seems to be largely that in making sure that we can have online meetings, which now has allowed government to eliminate a lot of the in-person meetings. That is where it ends. Their last press release by their website on this was November 2nd. John Marion is the head, and all I can say is, where have you gone, Phil West? Rhode Island cries its lonely eyes for you, because Mr. Marion appears to be a no-show on this. I personally reached out to Mr. Marion last year on a situation involving Peter Alviti and a what I believe to be an open meeting violation. I sought their general guidance. But in the case of Common Cause, some people are more equal than others, some concerns are more equal than others. And as is so often the case with many good government groups these days, right, they only pay attention to what they believe their constituency is, which is folks who are left of center. Now, I have a lot of friends who are left of center, and I'm glad that they get catered to, but not so much on the other side. Common Cause has no soul at this point in Rhode Island with regard to, anything. The nattering, chattering classes pay slavish attention to organizations like this because they're oh so hip and oh so important and oh so East Side. But when it comes to the reality for the average Rhode Islander, MIA, missing in action.
And that's been the story here in Rhode Island, not just Rhode Island, but specifically Rhode Island for a long time, Pat. Unfortunately, only certain causes that fit the narrative of the groups that want to pursue them are gone after. They are the ones that the so-called correct point of view. As long as you hold the correct point of view, groups like Common Cause will fight for it, fight for that information. If you don't hold that so-called correct point of view, there is that deafening silence that you talked about. And if you're going to be a government watchdog group, does it really matter what your politics are? Whether it's a Republican government, a Democrat government, a communist government, a libertarian government, whatever it is, don't you want them all to be transparent? Don't you want the information to be free-flowing to the public no matter what it is? It would seem to me that no matter what what side of the aisle the political aisle you might be on. That common cause would be, down your throat if you were not transparent. But that doesn't seem to be the case, at least anymore.
Phil West would have. That's all I'm saying on that issue. And we have to touch on one issue that approaches comical tonight with regard to the open meetings violation, with regard to the gerrymandering, redistricting, and that, of course, is the case of District 22 and the sudden presence of a very thin slice of Lincoln, Rhode Island, intruding into District 22. Geographical anomaly? I think not. Coincidence? No. What appears to have transpired was that with minutes ago, and if you go to, and we put all of this on the coalition last week, but if you go to the RI redistricting page, they'll talk about there were 4 different proposals: option A, B, C, and D. Option D was presented literally minutes before it was to go to a committee vote. And buried in option D was what? Chaz, who was doing what?
Yeah. Oh, you're going to make me say it, Pat, huh? Well, it appears that a certain senator redistricted or redrew the lines in a very strange way, that had not been proposed previously, and we can only speculate as to what those motives may be to have changed the maps as we had known them prior to option D becoming available. Mm-hmm. But it was apparently Senator Archambault.
Oh,
Senator Archambault, who I do know, and I have have a collegial relationship with Mr. Archambault, but it was Senator Archambault's district, if I'm not mistaken.
You are correct, sir.
That I would say appeared to have benefited from this. Am I wrong if I use that word? Is that a correct word, Pat?
Appears to have benefited, purportedly, allegedly, preposterously. It has been alleged, so I'll say it, by some, that an analysis of the Lincoln, Rhode Island land records, a transfer of ownership of property recently took place. So said senator may now own property in what was formerly Senator Paolino's district, I believe being District 17. A total of 600 or so voters were moved from 17 into 22, so that said senator could retain his senatorship. Now, while it being outrageous, there's a touch of rogue humor a la Rogue Island associated with. I will point out, as someone pointed out to me, that the town of Lincoln now has got to go to the cost of setting up a new polling district with all the attendant issues and costs. So it will cost the town of Lincoln money. It is grotesquely inappropriate, if in fact we have yet to hear public comment, as so often is the case, from said senator saying, no, that in his case, thou doth protest not at all. And so here we go again. Another one of those funny cocktail stories that you get at East Side cocktail parties, which I'm no longer invited to. I have no idea why. I'm hurt.
No, I'm sorry, Pat. I'm very sorry.
All right. So, because it's all cute when it's a Democrat in the state. Oh, that character. Oh, can you believe he did that? No. Can you believe you let him get away with it? Right. That's what it really comes down to. Can you believe that he re-engineered voting in this state? You are obsessed as a state with what happens with voter rights in other states. Yet when it comes to salient voting issues as they are impacting the people of Rhode Island, you have nothing ever to say.
It's unbelievable, Pat, that because I hear it from the chattering class in Rhode Island here, the elites, we'll call them, the outrage, the disbelief of the laws of other states as they impact voters. Let's say Georgia, Texas, for instance. They're very loud about what's going on over there, but
virtue signaling
here in Rhode Island, our own voters are being affected. Which way you can characterize it, whatever way you want to characterize it, but I don't hear very many people talking about it. Certainly not in the way that they're talking about it when Republicans openly gerrymander their districts in other states. And then we have, a democracy in crisis and,
Right.
the whole, our entire country is at stake when this happens, when Republicans do it. But when Democrats do it, it's like the ongoing joke in Rhode Island. It's like, oh, here we go again. It's like, it's funny. We laugh about it. It's like, we're Rhode Island. This is just a Rhode Island thing. It's cute. It's not cute, and we shouldn't be laughing about it. And we shouldn't be making jokes about it. We should be doing something about it. Instead of worrying about what Texas is doing, let's take care of our own house and take care of our own business and make sure that our own people are being taken care of here without the partisan influence that's going on in our state house.
And by the way, it's not just Lincoln Smithfield. Let's just kind of give a quick snapshot. There's issues in East Greenwich. Where else? There are issues in Cranston. Where else? There are issues all over the state.
Yeah.
And let's just see. What's the word of the day? Alacrity? The alacrity with which the Rhode Island political environment responds to an issue that elsewhere they consider very, very serious. Very, very serious. Don't hold your breath, as my father would say.
Yeah. Might pass out.
Final, just a quick minute or two on this. I'm going to give you my theory on how this is going to go down, and I want to hear your interpretation. Today, a Supreme Court justice apparently resigned or slated his retirement. Justice Breyer was, and I'll from the observation of someone who follows the Supreme Court but is certainly not expert on it, was considered a pragmatic, left of center, but common sense sort of guy. So now, enter the 21st century political environment that surrounds Supreme Court justice appointments. We know that the President of the United States has promised during his term to appoint a woman of color to the Supreme Court. I fully expect him to do what he's done for just about every other left of center concern, which is to ignore it. And he'll have some rhetoric to it. But to me, what's going to be interesting about this is that if he does not honor that commitment, that will go down with every other single failure of the Biden administration's commitment to very left of center causes. We're talking about student loan issues. We're talking about immigration issues. We're talking about voter issues. We're talking about literally just about everything he has failed them on. So to me, the most interesting part of this process is going to be watching progressive Democrats literally lose their mind as neoliberals, corporatist liberals do what they always do, which is sell them out. I personally can't wait for the sheer entertainment value. How about you? What doth thou say?
I mean, these Supreme Court battles, they're always entertaining to watch. And, I will say that Justice Breyer is a very pragmatic justice. And although he is left to center, like you said, I don't always agree with his philosophy, judicial philosophy, but he tended to be very pragmatic and formed coalitions with other justices that I don't think are going to exist with the placement of his replacement justice that's going to come under a Biden administration that has hewed so far to the left that it's so, I think it's unrecognizable from the Joe Biden that we knew decades ago. So I'm fairly excited to see hopefully a qualified jurist appointed to the Supreme Court that will be I'm going to show my naivety here and say, hopefully will uphold the rule of law without partisan interference. And I hope, for the sake of Mr. Biden and his administration, that the Supreme Court justice is successful in doing those things, because our democracy depends on it. It's not going to change the composition of the court. The composition of the court, if you're looking at it from an ideological perspective, is well, I'm going to call it a 5-4 court, because I don't think Justice John Roberts counts as a right-wing justice. But we'll call it, they call it 6-3. I call it 5-4. It is not going to change that composition, but I'd hate to see President Biden pick somebody simply based on their ethnicity alone. There are plenty of qualified jurists out there, people of color, who are more than qualified. We have a person of color on the Supreme Court who is eminently qualified already. So let's go out there, pick somebody who has the qualifications, that meets the criteria that he's looking for, and is going to do right by the Constitution of the United States.
Now, when I ask a question like this, I usually preface it with another, which is to ask you, Mr. Calenda, Attorney Calenda, are you in fact operating heavy equipment or drinking hot liquids?
I am not currently operating heavy equipment or drinking hot liquids.
So I'm going to go back to a few years, to a moment in Supreme Court history, which I found profoundly amusing, which was the recasting, if you will, of then Judge Sandra Day O'Connor as being the necessary voice of the middle. And as a result, should not be a profound ideologue, or should not be ascribed to right or left. Do you remember those halcyon days?
I certainly know of them. I don't remember if I don't have an actual memory of them, but I've certainly seen them in reruns.
Right. So what are the odds of Democrats everywhere standing up and saying, we need someone who's judicially independent, not attached to a left or right wing philosophically, and will be that voice of compromise? What do you think the odds of that happening are, Sparky?
I'm going to go with 0 on that.
So you're going with the Dean Wormer approach? 0.0.
Yeah.
0.0.
0.0. And that's not just the Democrats. I mean, the we saw 3 appointments by Donald Trump, which were, come off the list of the Federalist Society. And, as much as some of those justices may be very, very, very qualified, I don't want them for their political views. I want them there for their fidelity to the Constitution, for their fidelity to the rule of law. And I would really hope that the Democrats would want the same for their next pick.
But in defense of the Republicans, I don't think the Republicans have ever, and the term really didn't exist back then, virtue signaled about an opposing organization's pick being of a necessity, being a moderate, being a centrist, being someone who did not ascribe to theory. They were not so blatantly hypocritical. They never made that assertion. The Democrats demanded, when Sandra Day O'Connor announced she was retiring, that someone occupy that honest center, that honest middle. And, I'm just wondering where that firm resolution has gone.
It's gone to the same place that the 2019 or 2018 letter that was signed by all those senators the bipartisan group of senators that said we should, or most, and a lot of them were Democrats. There were a few Republicans on there, but the bipartisan group of senators who said we should never eliminate the legislative filibuster because it protects the minority party. It's what you just talked about is going the same way as that.
Oh my. Well, Attorney Calenda, it has been an adventurous show. We have covered issues solemn and tragic, and we ended it with a little dark, as it were, lighthearted, well, self-directed humor. Thoughts for the week coming up?
Well, I can tell one thing. I have a major announcement to make. I am not running for Congressional District 2.
Thank God.
So we can take the speculation right out of that one. So put that all over social media. I am not a candidate for Congressional District 2, but I am interested to see how quickly President Biden nominates the next potential Supreme Court justice. I'm certainly interested to see how this term in the Supreme Court is going to play out. This is going to be a very interesting, potentially earth-shattering term for the United States Supreme Court. And I'm certainly interested in see how the political scene here in Rhode Island plays out, particularly with the state offices, because as far as I can tell, only one party has people lined up for pretty much every state office. And the other party has one person lined up for a state office. Who's that person, Pat? I'm not really sure who that might be.
I want you.
Oh man, that's fine. My identity is not that of a Republican attorney general, like I've told people many times. My identity is that of someone who wants to be the attorney general for all Rhode Islanders. So I hope people will keep that in mind when they look at whether or not they believe I have the necessary qualifications to be the chief law enforcement officer for the state of Rhode Island.
Well, until next week. By the way, tomorrow, and the coalition will be reporting out, the Supreme Court of the great state of Rhode Island will be meeting to discuss if you will, an appeal. I'm not sure what the technical term it is, but a case seeking to void, do I sound like a lawyer there? The landmark legislation in last legislative session that enshrines, if you will, Roe v. Wade into Rhode Island law, or the impacts of Roe v. Wade. That has come under legal assault, and that will be taking place at about 10, 11 o'clock tomorrow morning. So we'll be watching, and we'll be eager to report the outcomings of that. And I would assume that'll be fodder for conversation on next week's Chaz Calenda, Attorney at Law.
I'm certainly interested to hear that argument myself.
Bring us home, buddy.
Well, as usual, I'd like to thank everybody for joining me here on Chaz Calenda, Attorney at Law, and listening to the conversation Pat Ford and I had, the banter and the somber conversation that we did have tonight. We usually do this on Wednesday nights here on the Coalition Radio Network, around 8:30 or so, give or take a few minutes. And you can find me, Chaz Calenda, at the law firm of Inman and Torgy at 1500 Nooseneck Hill Road in Coventry, 401-823-9200. For those of you interested in my campaign to be the next Attorney General of the state of Rhode Island, you can find me at the website Chas, CHAS, 4AG.com, where you can learn all about me and my background and why I believe I will be the best choice to be the next Rhode Island Attorney General. Thank you all again for joining us for another episode of Chaz Calenda, Attorney at Law, and I look forward to seeing you on the next episode. Pat, thank you as always, and have a great evening.
Good night, folks.